number 92, Princess Point versus Muss Development. Good afternoon, sir.
Good afternoon, Your Honors. May it please the Court, my name is John Ciula of the law firm of Rosenberg, Calico, and Bernie. On behalf of the appellant, I'd like to reserve 2 minutes for rebuttal.
You may, sir.
In the order, the appellate division committed reversible error in the first instance by erroneously determining that merely by bringing this action, which included a rescission claim, that the appellant anticipatorily repudiated the party's real estate contract.
Counsel, I have a factual question before we get into that. The last extension date, let's call it, is July 22nd, 2008, I think, right? If nobody does anything, action isn't brought, but nobody does anything, neither party does anything, what happens under the terms of the contract?
The contract would terminate.
Without action by any party, and then the deposit would be refunded?
I believe so, Your Honor.
And what about the money that's paid in to help in the effort to comply with whatever the environmental rates
I
are?
believe that appellant would be entitled to receive the down payment as well as the compaction payments.
I assume you're relying on Section 5.2 to say that the contract terminated if nobody did anything by the outside closing date?
Well,
Well, let me
Yes.
let me ask it this way.
well, okay.
Let me ask it this way.
Sure.
I don't read Section 5.2 as saying anything about termination. It doesn't have the word termination in it at all. Section 5.3 does, and it gives a right of termination if, at any point after the outside closing date, one party gives the other party notice, and then you have to provide 30 days' notice. Is there anything in the record saying that either party sent notice of termination?
No, there is no indication in the record that either party gave notice. But the way I would answer the question is this way, Your Honor. If the last outside closing date came and went, there was no closing, there was no conveyance, the respondents had an obligation to satisfy a condition, express condition precedent of obtaining developmental approvals by that date. To the extent that they did not, and of course they did not and could not, I believe the contract would have terminated.
Then what's the purpose of the language in Section 5.3 that says if the outside closing date has come and gone, the parties have the right to terminate with 30 days' notice?
Well, I think that section also provides that the parties have a right to extend it, and they did here. But there was a last outside closing date. And to answer Your Honor's question, I believe that if that closing date came and went and there wasn't a closing, that the contract would have terminated. And I believe that the respondents have taken that position in the litigation.
Well, what would otherwise be the purpose of a closing date? If not to have the closing on the property, of course, but
Right.
some end termination to this contract.
I'm sorry, Your Honor.
I'm sorry, I'm not clear what, well, I'm just trying to appreciate what would be the point of a closing date. Obviously, it's to close on the real estate transaction, I understand that. But otherwise, to indicate the last day of the contract. I mean, what?
Well, it would indicate that at that point in time, the parties were required to perform their various obligations under the contract. And in this particular situation, if that closing date had come and gone, and the respondents had not satisfied the express condition precedent of obtaining all of the development approvals, then I believe the contract would have terminated.
So the date comes and goes. 2 months later, they get all the approvals they need, and they call up and say, we're ready to close.
As I understand the contract and the law, Your Honor, I believe that the contract would have terminated by that date.
In Section 5.3b, if a party receives notice of termination after the outside closing date has occurred, gives the counterparty the right to waive the conditions that haven't been met and close anyway. Is that right?
That's correct.
Can I just ask you a little about what's actually before us, your understanding of what's actually before us? The way I understand it, causes of action 1 and I think 3 are before us. Is that correct? But the forbearance clause issue, cause of action 2 is not before this court today. Is that right?
Counterclaims 1 and 3, Your Honor.
Counterclaims, I'm sorry. So 2 is not before us. So the forbearance clause issue, the arguments that were before us and in the briefs and also the appellate division's reference to it really are not pertinent to the decision that we have to make today. Is that your understanding of it?
That's correct. The only.
Tell us why.
The only issue before this court is whether or not the respondents are allowed to retain the down payment and the compaction payments.
Right. Now, take a step back. The case was pled, as I understand it, as rescission and reformation. Is that your understanding of it?
Well, if I may just briefly go through the causes of action, there was a cause of action for specific performance of the original contract with an abatement of the purchase price. A rescission, a claim for rescission and/or reformation of the amendment, and also included within the complaint, the amended complaint, was the appellant sought relief to enjoin the termination of the contract pending the lawsuit.
You don't need to go through them like that. We don't need that. The reason I ask you for this question is because it seems to me many of the arguments that are addressed in the parties' brief in the appellate division's decision as a reference to rescission really revolve the question of whether or not this was an action for reformation.
I believe that's correct, Your Honor. It was never an action about rescinding the entire contract.
So talk us through the timing of this lawsuit.
In what regard, Your Honor, if I may?
It's a little curious to me, I'll speak for myself, that the lawsuit was brought at the 11th hour.
Well, I'm not passing the buck, so to speak. My firm didn't represent the appellant at that particular point in time. I frankly don't understand the thinking of bringing the lawsuit at that time, except that it seemed pretty clear in looking at the record materials that the respondents were not able to obtain the development approvals and close by the last outside closing date. And it appears that what the appellant was trying to do was to protect itself and vindicate its rights under the contract, to try to move forward with the contract and proceed to a closing, but without some of the terms in the amendment or the amendment altogether that they felt were procured by fraud.
So is there any case law that you know of that equates commencement with rescission?
No.
No. So the theory, I suppose, would be that they were making an action for reformation. I assume they were trying to get a closing, not get a closing.
If Your Honors look at the complaint in the record materials.
Yes, but isn't there only one contract? It's the one that was amended, and that's the one that you're trying to rescind?
That's
In
correct.
that sense, you're not reforming that one, right? Or that's not what they were requesting.
No, there
What
was
they're requesting is, we don't like this deal that we entered, and they give reasons, right? They claim there's fraud in the inducement, I didn't understand, whatever. I don't like this deal, I like the prior deal.
They were
But
seeking.
the contract is this deal with the amendments.
Correct, but the law seems pretty clear to me that the refusal
still
to
find out.
perform has to be unequivocal, unqualified, has to be absolute and definitive. If you have, as you have in this case, claims that seek to keep the contract
But I
alive.
guess that's what I'm saying, it's somewhat begging the question. Does this turn on whether or not we are in agreement with you that what you're trying to rescind is only the amendments versus, as the department saw it, the division saw it, that you were rescinding the contract because the only contract was this amended agreement?
No, Your Honor. Look, I think this is a better case, if you will, because of the actual claims. But if it was just a straight-out rescission claim, I'm not sure that would make a difference because, as we argue in the briefs, the fact that a party to a contract is seeking an equitable remedy like rescission does not mean anything other than they're asking the court for that remedy. It doesn't mean that they're terminating the contract, they're canceling the contract, or rescinding the contract themselves. But here, it's
So
better.
simply stated, if you had lost and the court says you're bound by it, your position is then the clients would have complied?
They would have complied.
Thank you, counsel. Mullen?
Good afternoon. My name is Scott Mullen. Eric Feinstein, represent the respondents. I had the privilege of listening to Supreme Court Judge Stephen Breyer and at a different time Judge Kaye talk about the importance of common sense, the importance of being practical, because when decisions are rendered that are not practical, it doesn't generate respect from the public. Here's what happened. This is not an unusual fact pattern. A rising market in 2004, they sign a contract, buy it for $35 million, they're enthused. Although their papers say that the amendment was foisted on them, they always had the right in this contract because everyone understood this is a former waste site that had to be cleaned up.
Okay, they may have whatever motives you suggest, but isn't the legal question whether or not filing the lawsuit is them saying, we will not comply with this contract ever, unequivocally, making that statement that they will not abide by their duties and obligations under the agreement?
Judge, I agree with you, and you, in the prior case, you talked about...
It's a good thing, yes.
I'm sorry?
It's a good thing that you agree. Go ahead.
I hope so. In the prior case, you talked about ordinary meaning. That was important. You have a seller who saw they were accused of fraudulently inducing the other party into the contract. The request and the complaint, if one looks at the complaint, it was for rescission. Okay, rescission means terminate the contract.
In addition, it was repeatedly for an injunction permanently restraining and prohibiting the defendant sellers from terminating the agreement of sale.
You're looking, I believe, at the addendum provision. I may be wrong.
Yes.
But if one looks at the facts in the pleading and
And they
one looks at the
complied
course
with-
of
This is the
action...
relief requested.
I'm sorry?
This is the relief requested, is for an injunction preventing the termination of the agreement.
I know what they said in their addendum. I also know that what happens in a real estate transaction where you are trying to accomplish that, you move for a temporary restraining order to restrain toll the expiration of the contract. You then ask for a preliminary injunction. No such motion was made.
Slow down. Then every theory that's pled would amount to a legal conclusion under what you're arguing to the court. We'd have to take as a conclusion that the contract was rescinded, that the contract was reformed. Contrary pleadings wouldn't make any sense. The theory that you're offering us, to go back to Judge Kaye, just common sense. How can people do business in this situation? The way you do business is you come in and you have 5 or 6 different arguments. Some of them may work, some of them may not work in a legal setting. That seems to be what we have here.
You don't have it for this reason.
Okay.
Their argument, that's their argument, that
Right.
they alternatively pled. Here, the pleading, the cause of action is to terminate the contract or specific performance with an abatement. It's very important with an abatement. That is a clear statement to a reasonable person. The seller took it that way.
But isn't it clear from the complaint that they still wanted to purchase the property?
No.
Just not on these terms that
Judge-
they entered into in March of
Judge-
whatever it was, 2006.
There's an old expression, if I can inject a little humor to make a point, watch the hands, not the lips. The conduct, the course of conduct here was to commence an action before the expiration date. Paragraph 10.2 is a key paragraph. 10.2 says that if you don't
So if they wanted
close,
to terminate, couldn't they have done that in whatever, 2 days, 48 hours, whatever it was?
they had the right. The
Sorry, can
interesting,
you finish that sentence? If they don't close,
before the expiration, if they don't close and the contract
Before-
expires, the seller gets to keep the
no, it
deposit.
actually says on or before the last date required by this agreement. It doesn't say the outside closing date. Is there a reason for that?
Last date required by the agreement. And
But it
that
doesn't
was,
say the outside closing date. Is there a reason for that? Let me ask it this way. If, just hypothetically, if the contract isn't terminated, does that affect who gets the deposit?
well, under this contract, the terms of this contract provide either party had the right to terminate. They could have gotten their money back if they had terminated properly.
And I think there's nothing in the record, is that right, that either party terminated? Sent in a notice of
That's
termination?
correct. And there's a ruling at page 9, which has never been appealed, which is now the law of this case, that says that the contract expired by its terms. That's the ruling of the trial court. It is not before this court. So that is now the law of this case.
Well,
So-
isn't by its terms the closing date if you have not extended it?
Correct.
Isn't that
Yes.
this agreement.
It is the closing date, and it was the July date. And in fact, in our brief, we cite to the malpractice, their remedy, they claim their lawyers never told them and sued their lawyers because they never told them by suing before the closing date that that could be an anticipatory breach. That's the action against their law
Really
firm.
aren't, if you go to common sense, aren't really what they're trying to do is extend this contract. You don't really want to sell them the property. They actually really want to buy it. So the roles are a little bit reversed here. So getting back to the chief judge's point, they bring this action on the eve of this thing expiring because they really don't want to cancel this contract, right? And then you, later, bring these counterclaims, which I think originally alleged breach, not anticipatory repudiation, saying, oh, you breached the contract, when you really never wanted to sell them this property anyway under these terms. So to get into the common sense, because you are grudgingly extending that closing date, right? You're negotiating those extensions, and it's very stringent negotiations. This is the last one. So yes, they bring this to kind of stop the clock. And then yes, you bring a countersuit saying, oh, you breached the agreement. But was there really, if you're going to get under the common sense of this case, was there really ever any will on the part of the sellers here to sell this property to them under the terms of your contract?
Without question, because under the contract, they had the right to close. Everybody knew this was a long-term permitting process. They understood that. The contract reeks of that. The correspondence reeks of that in the record. They had the right not only to terminate the contract, walk away at any time and get their deposit back, but what they had the right to also do is to close and take over the permitting process, and they could have done that as well.
Would you-
But in 2000, if I may just
ahead.
answer Judge's question, in 2008, the market was collapsing. Our client, you asked, did our client ever really want to close? Of course our client wanted to close. In 2008, they would have closed. 2009, 2010, our client would
Why
have
didn't you
had
extend the
37
date?
million reasons to close.
Why didn't you extend the date further then?
Why? Because they, among other things, they were so anxious and so optimistic about the value of this property, they increased the price in the amendment by $2 million, increased the price. They increased the deposit from 5 to 10%. They, in writing, acknowledged that the seller had complied with all of its obligations with respect to permitting, and they covenanted not to sue.
And
All-
that's the first way the contract saved, I think, in 2006, right? And there's no, let's call it a bailout, coming in '08 when this is expiring, so they bring this lawsuit, instead of getting an amendment.
Yes.
But it's the same principle operating, which is, and this is the market. The sellers think, this isn't a great deal for us, we're not extending this anymore, and the buyers think, we want this deal, and we're going to lose it.
The comment, Judge, is, in your prior statement, you used the term brought the suit to stop the clock. No, that's the whole key here. The clock was ticking. That's what the trial court found. If, in a typical real estate transaction, if you want to stop the clock, real estate people are pretty shrewd litigators. You go to court and ask for a TRO and a preliminary injunction, you toll the closing date. But then if you do that, to make sure it's not frivolous and baseless, you have to post a bond.
Well, what's
And what
not
they
being
did here
talked
is they
about-
avoided the preliminary injunction, never posted a bond or a TRO because they didn't want to put up a dollar.
What's not being talked about here is the conditions precedent to the closing, and whether the sellers were ready, willing, and able to comply with those conditions. Can we talk about that for a moment?
Yes, there is not a single page in this record that shows that the seller was not able to deliver marketable title. In fact, the record shows the seller was willing to go to closing. And by the way,
Well,
page
then
410...
how does the seller get summary judgment if
Because-
there's nothing to show that?
Because there was an anticipatory breach, and the case law makes it clear. Once there's an anticipatory breach, all obligations going forward cease.
Well,
So
haven't we at least implicitly said, if not explicitly, that there's a difference between actual performance, tendering performance, and demonstrating the ability to perform?
the cases that are being spoken about are cases that the other side relies on, are almost all distinguishable along those lines.
Big cases, Pesa v. Yuma, I believe.
Yeah, many of these cases are declaratory judgment actions or actions for damages. They are
Well,
not
but the theory
liquidated.
that Judge Stein put forward is the same theory as the theory in Pesa v. Yuma, that the parties are reversed, one's
Pesa-
a buyer and seller.
Pesa
But
is
the
highly-
theory, excuse me, is still the same.
PESA is highly distinguishable. In PESA, among other reasons, first of all, they said there were issues of fact. There was an issue of whether there was in fact a repudiation because a lawyer gave an affidavit and then he seemed to modify it and retract it. That was one of the issues. Another issue was the buyer said the seller had not complied with their certificate of occupancy issues, and there was an issue whether they could have delivered. None of those facts involved a liquidated damage provision where the parties contractually agreed, if the contract expires and you haven't closed, then you are entitled, the seller, to keep the deposit and the compaction payments. We have a contract, 10.2, and the other provisions that relate to it make it different, very different than the cases they've gone all over the country.
Thank you, sir.
Thank you for your patience.
Mr. Ciula?
It's clear under PESA, what PESA did is this court reaffirmed very long-standing, well-settled principles that in order for a non-breaching, non-repudiating party to recover damages, it must show that it's ready, willing, and able. That's a form of causation. Here, not only did respondents fail to tender any evidence to show that they were ready, willing, and able, in fact, the record is clear because of Mr. Seidenwar's affidavit that they could not get all of the development approvals.
Let's say, counsel, let's say we agree with you and this isn't an anticipatory breach. Do they still have some type of breach claim they can bring? I mean, we talked about stopping the clock, so now we're how many years after this? Can they come in and say, we were ready, willing, and able, and you breached on July 22nd, 2008? You didn't terminate. Do they have anything left if we agree with you that bringing this lawsuit is not an anticipatory
No,
breach?
Your Honor, I don't believe so.
Oh, wouldn't they have the forbearance clause action still alive? And then it'd have to go back to the court. The court hasn't made a ruling on that. So the most you can leave here with is 1 and 3. 2 would still be alive, wouldn't it?
Well, let me say this, Your Honor. They would still be required to show that they're ready, willing, and able. Why should they be
I
given
understand that,
a
but let's say
second
they
chance to
could.
do that?
Let's just, for argument's sake, say they could. Then there would be a measure of damages for that time period that the trial court would have to make a determination on.
I don't agree, Your Honor.
Okay.
It's very clear to me that they had their chance to show that they were ready, willing, and able on this set of claims. They failed to do it. They should not be given a second bite of the apple, if you will, to do that.
Thank you.
Thank you.
Thank you, counsel.